This Honorable Court of Criminal Appeals is now back in session. You may be seated.
Thank you, Madam Clerk. This is the afternoon docket for the September call of the Court of Criminal Appeals in the Western Section. The lineup hasn't changed from before we broke for lunch. From the East Section over here to my left, Judge Kyle Hickson, and to my right from the Western Section, great state of Tennessee, Judge Ross Dyer. I'm Tim Easter from the Middle Section. Any preliminary matters for this afternoon?
Yes, Your Honor. General Coleman would like to make an introduction.
General Coleman.
Good afternoon, Your Honors, and thank you for the indulgence. I wanted to introduce someone from our office who has his first argument before this court today. This is General Ray Lapone. He is new to us. He graduated from the University of Memphis and then spent a significant period of time in the Shelby County District Attorney's Office, and we're lucky to have him, but I wanted to introduce him to the panel.
Thank you.
Good afternoon.
Good afternoon. Looking forward to it. Thank you.
Thank you, Judge.
I think we've seen his name before on cases that have come through on records and so forth. I think I have. Yeah. Okay. Thank you.
He tried a bunch of stuff in the DA's office, too.
Yeah.
One or two, yeah.
All right, let's call the first case on the afternoon docket.
State of Tennessee versus Cornelius Williams IV.
Mr. Chisholm, good afternoon, sir.
Good afternoon.
Would you like to reserve any rebuttal time in your 20-minute argument?
Yes, Your Honor. 2 minutes rebuttal, please.
2 minutes, yes, sir.
Thank you, and may it please the court. I'm Lance Chisholm, Shelby County Bar, represent the defendant, appellant Cornelius Williams. The first issue I'm going to discuss today is the faulty jury instruction. Now, this was not objected to and was not put in the motion for new trial, so I am relegated to plain error. Plain error, it's my burden to show that it's likely the verdict would have been different had the error not occurred, and I do acknowledge it's my burden, and I intend to show that today. So what happened in this case, the trial court told the jury that in defining second-degree murder that you have to find that the defendant or one for whom the defendant is criminally responsible unlawfully killed the victim. Same thing for the felon in possession charge. Said, you have to find that the defendant or one for whom the defendant is responsible possessed the firearm. The problem with that is that in this particular case, it left a lot of room for confusion because in this case, the jury heard that the murder weapon used to kill the victim was found on a carjacking suspect in the same city, Frazier, about 2.5 weeks after she was murdered. And I think, part of the defense argument was, we weren't the ones who killed the victim. It was probably, it was probably the carjacker over there, the one who had the murder weapon. So, that's problematic when you're telling the jury that either the defendant is responsible for this crime or one for whom the defendant is criminally responsible, because the trial court never defined what criminally responsible means. I mean, what does that mean, that term? You don't hear that a lot in ordinary language, criminally responsible. So the jury could have thought, well, heck, we don't necessarily find that Mr. Williams killed the victim, but we think that the guy with the found with the murder weapon, the carjacker, did it, and he's probably somehow responsible for that.
Mr. Chisholm, I think your problem is, though, that you're under plain error. I mean, your argument makes a lot of sense if we weren't looking at it under plain error. And under plain error, one of the things we look at is the evidence against your client. There were eyewitnesses to the shooting that saw your client shoot her. So how do you establish that element of plain error if based on the state's proof? I get that the defense raised these questions, but since we're under plain error and we're looking at the overwhelmingness of the evidence, how do you establish that element of plain error?
Well, Your Honor, I would respectfully submit that under the fifth prong of plain error, which is whether a substantial right of the accused was adversely affected, that's when we do look at the proof, and I would respectfully submit the proof was not overwhelming in this case. And I knew that that question was going to be asked, so I'd like to kind of go through what the proof was and to show that it was not very substantial if you really look at the proof, because what you have here, you have about 5 pieces of the puzzle, and I'm going to briefly analyze each one. Ronald Stevenson, he was the neighbor across the street. Now, he did see the defendant and the victim arguing with one another on the afternoon of October 3rd. And, you know, he also, Mr. Stevenson, had a little bit of a history with my client. My client had gotten on to him in the past for having, you know, Mr. Stevenson worked on cars, and his customers would oftentimes park alongside Mr. Williams' fence line there on the street. And there were some arguments about that in the past. And Mr. Stevenson had a criminal record. He was on house arrest for a felony, federal offense. So the thing is, he sees them arguing earlier in the day, and he sees my client with a gun earlier in the day. However, that night, he heard shots. He goes outside. He sees my client. My client's looking around as if, you know, he's trying to see who did the shooting. And he never saw my client actually shoot the victim. So I think Mr. Stevenson doesn't really establish, you know, that my client was guilty of this murder because he never actually saw it. He came after the fact. He even asked Mr. Williams, "Hey, did you fire those shots?" And Mr. Williams said, "No, yeah, I didn't do that." So Mr. Stevens doesn't get us where we need to be. Tommy Jackson was the second main witness. He also saw Mr. Williams walking around that day with a gun that afternoon, and then he came back later that evening, and he heard, he saw Mr. Williams arguing with a female. He could not see who the female was, though. He just heard a female voice, and then he drives off. 6-7 minutes later, here's the gunshot. So again, Mr. Jackson never saw exactly how the murder happened. And Mr. Jackson was good friends with Mr. Stevenson, and he had also, Mr. Jackson had been into it with Mr. Williams in the past too. Over the, I think Mr. Jackson used to hang out and drink, excuse me, on a sidewalk, and they had gotten into arguments over that. So there was a little bit of animosity there. I think that's important to point out. So that's those 2 witnesses there that really didn't see what happened. And then the third one is CM. That's the 4-year-old child. Now, this is the biological daughter of the victim. This is not my client's biological daughter. I think that's important to point out. And so she told the forensic examiner when she was 4 years old, right shortly after the shooting, that she saw my client, shoot the victim. She was standing in the little door there and looking at the window through the door. However, at trial, when she was 6 years old, she testified she heard the shots, but she did not see anything. She did say at trial that what she told the examiner was the truth, but again, at trial, she actually said she didn't see anything happen. So I would submit that that does not establish that Mr. Williams committed this murder either. So really, we're left with one witness, Bobby Bingham, 16-year-old, lived 2 houses down from where the shooting occurred. And again, he says that this is 11 o'clock at night. I think this was a Sunday night. He hears screaming, looks out his window. And I think it's interesting, this language he used. He testified he saw 2 figured bodies between the 2 cars. Again, it's nighttime, it's 11 o'clock. Just that language itself, 2 figured bodies. Now, he did go on to say those 2 figured bodies were the victim and the defendant. I mean, he definitely said that. But that choice of language there, I think, should erode any confidence we have in what he's saying. I don't know, just something about that I really picked up on that when I was writing the brief, the way he described that. It makes it sound as if maybe he didn't quite see, 2 figured bodies. It just doesn't seem very confident, but He said he was confident, you know, I do acknowledge that, you know, that he saw the victim and the defendant, he knew them from the neighborhood, walking around. But there are other problems with Mr. Bingham's testimony. He acknowledged that at the preliminary hearing, or he said a prior court hearing, I'm assuming they're talking about the preliminary hearing, he had had to be asked 3 times to identify the defendant before he actually identified him. He acknowledged that on cross-examination. He also acknowledged that right before that preliminary hearing started, a courtroom deputy told him, go in there and identify him. And lastly, he was good friends with Mr. Stevenson, apparently, because Mr. Stevenson drove Mr. Bingham to the preliminary hearing. And as I stated earlier, Mr. Stevenson had a history with Mr. Williams. And so, you know, he's the one driving Mr. Bingham to go identify Mr. Williams at the preliminary hearing. So for all those reasons, I would respectfully submit that the proof was not overwhelming. In fact, as I argued in my brief, argued the evidence was actually insufficient. So that's why I think that I can meet my burden of showing plain error, because, you know, had this not been a case where a murder weapon was found on somebody else, had the proof been a lot stronger, then yeah, I probably wouldn't have had an argument here. But this instruction really, it was truly error. For
So,
someone,
but there's also case law out there that talks about when you're looking at it under plain error, when there is strong proof, and when the state does nothing but argue that the defendant is responsible, that you can't meet the plain error standard.
Right, and there is case law.
Which is what you have here.
Well, my response to that would be, it is true the state argued my client, you know, Mr. Williams was the perpetrator. They did not argue criminal responsibility. However, doesn't mean the jury, just because that wasn't argued, they still could have been confused by the instruction and thought, well, I mean, who's to say the jury wouldn't have thought, maybe he is somehow responsible, you know, carjacker's gun over there. He thought she was cheating, you know, like maybe he's somehow involved. But, you know, when you're not told what criminal responsibility means, that's the danger. We don't know what the jury was thinking with this instruction. They could have convicted him on just a loose association of, yeah, he thought she was cheating. He obviously didn't like her. Somebody killed her. He had to be responsible, you know.
That's more of a, you're making a sufficiency of the evidence argument and not a plain error argument.
I think the plain error comes from just the instruction, you know, itself. I think this court would acknowledge it's plainly an erroneous instruction. And so the only issue is under Part 5, is it necessary to do substantial justice? And, you know, like Your Honor said, if the proof would have been overwhelming, I would probably have to concede, yeah, I don't think this probably made a difference. But as I went through with Mr. Bingham being really the only one who saw it, you know, like I said, CM back, you know, changed his testimony, I just don't think it's overwhelming. And I do think the jury could have very easily been confused by it. You know, responsible, what does that mean, responsible? I mean, they weren't told responsible means you have to have the intent to commit the crime and aid and abet, you know, the other person. So I will stand, you know, respectfully submit and ask the court to find plain error on that issue. Issue number 2, Your Honor, has to do with this pro se pleading that was submitted. Apparently, Mr. Williams allegedly filed this motion called Motion to File a Civil Suit for Wrongful Incarceration. The defense counsel did object. However, in his objection, he stated that, well, Your Honor, let me see how he worded this. This was something filed over in civil court. He wasn't represented by counsel, and that was his argument for why it shouldn't have come in, Mr. Dolan's argument. However, you know, the court let it in, and my position is under Rule 901 of the Rules of Evidence, there has to be an initial showing that the matter in question is what the proponent claims it is. Well, here we had nobody get up and say, yeah, you know, that's Mr. Williams' handwriting. Nobody said, I saw him writing this out.
Is the document not self-authenticating? It's got a signature on there twice, as I understand it, and it's been notarized. And the notaries would be saying, this person signed this document in front of me. So is it not self-authenticating?
I'm not sure. I know there is a list, I think it's under 902 of self-authenticating documents. And, you know, if I'm wrong about this, then I'm simply wrong, but I thought that was dealing more with things that are like government-issued documents. I'm not sure just the fact that somebody signs a pro se pleading and it gets notarized falls under that category of self-authenticating. My position is there would have needed to have been somebody to say either, hey, yeah, we recognize this is his signature, or that's his handwriting, or I saw him write it, or maybe compare his signature to something else that he's written before, signed before. And like I said, if I'm wrong and then the law says that when you notarize a pro se pleading that's self-authenticating, then I certainly stand corrected. I just didn't read the law to me. You know, I didn't think that that was the law based on my initial research. Now the state argues, well, heck, you know, Mr. Dolan said at one point, this was filed by the defendant in civil court. And they argue that that's kind of an admission that, you know, his client, Mr. Dolan's client, Mr. Williams, filed that. I don't read it that way. I think Mr. Dolan was just, you know, making a point like, you know, this was filed over in civil court. They didn't have a lawyer. Mr. Dolan wasn't saying like, oh yeah, my client definitely filed that and he filed it in civil. I don't read him to be saying that. So I disagree with the state about that there was an admission by the lawyer that he filed this. The question is this necessary to do substantial justice, admitting this pro se pleading? I submit it is because this is actually pretty important. This is actually where the client writes out what happened. You know, if you believe that's him, you know, who filed it, and what he wrote did not match what he told the police in his interview. Because he told the police he's on the couch with his daughter watching football. The victim comes in, gives him some cigarettes, walks out. Then Mr. Williams hears the shots, goes outside and sees her. In this pro se pleading, he's asleep on the couch. He hears the shots, he gets up, goes in the bedroom where he thought the victim was located, grabs his .45 caliber gun, that gets him on the felon in possession charge, and then he goes outside. So. And this was hammered in closing argument, that it's the difference between the pro se pleading and the statement to the police. So for that reason, I think it is necessary to do substantial justice because it was a pretty powerful piece of impeachment evidence, quite frankly. Now, the cumulative error issue, decisions from this court have said cumulative error must be raised in the motion for new trial. These are unreported cases, though. State v. King, which actually cites an appendix another reported case, and then State v. Bates. Other cases seem to not have answered this question. In State v. Lane, the court said the state maintains cumulative error is waived since it wasn't in the motion for new trial. The court went on to say, regardless, we find no error, so the court never really got to that issue. I would respectfully submit cumulative error should not have to be raised in a motion for new trial. The best time to raise that is on appeal. And I think the Seaton case, there's some language about, yeah, it's awkward at best to try to raise cumulative error in a motion for new trial. That's from this court, State v. Seaton, and I agree with that. I think the best time to raise cumulative error would be up in the appellate court. If the court disagrees with that and finds that it does have to be raised in the motion for new trial, I would submit that under plain error, this court can find that two plain errors combined to form a super form of plain error, which is what I'm asking the court to do here, and confine cumulative error under two plain errors. Sufficiency, I'm going to rely on my brief for sufficiency. Sentencing, the only thing I want to say about that, it is certainly illegal, the 35% for the convicted felon charge, but that was mentioned on the record, the 35%, I believe, range 2. And so I would submit it is a material element since the percentage was mentioned, if I'm not mistaken, on the record. And now we find out it's going to be at 85%. That's a big difference there. And
a material element to what?
To the agreed upon sentence that the state and the defense agreed upon.
But this, as I read it, yes, the state and the defendant had to discuss this. The trial court's not bound by that. This is not a guilty plea.
That's correct, Your Honor, but my position is that since the defense, their understanding was, as it was said, 35%, and you find out it's going to be a higher percentage, that agreement needs to be sent back to reconsider that agreement.
But that's what I'm saying, the agreement's great, but the agreement carries no weight. It's up to the trial judge. And then the two parties can come in and say, Your Honor, we want to plead to, we've agreed this is the sentence. The trial judge can say, I don't care.
No, I understand, Your Honor, but I think since she accepted that agreement and it was based on an incorrect understanding of the law, and again, it might be better for post-conviction, I don't know, but I think that the way I read it, this court could say, hey, we need to send it back because, the parties and even the court were operating under the wrong assumption.
It's got to go back regardless because it's illegal, correct?
I think that the state proposed this court could just impose the 85%. If the court feels it's not material, could just impose the correct sentence and would not have to send it back. If the state's position is accepted, it's not material.
Well, it's got to, I guess my point is it's got to go back for a new judgment to be entered. Whether we do it or whether the trial judge does it, the sentence has to change.
That's correct, Your Honor. That's correct. And so I would respectfully ask the court to reverse and dismiss, or an alternative remand for a new trial, or an alternative remand to give the parties a chance to renegotiate the sentence. Thank you.
Thank you. Mr. Douglas.
May it please the court, good afternoon, Your Honors. Davey Douglas on behalf of the state. This court should affirm the defendant's convictions, but this court should remand for the entry of a corrected judgment reflecting a legal sentence of 4 years with 85% release eligibility. But before getting to the sentence, I wanted to address the jury instruction issue here. And consideration of this issue is not necessary to do substantial justice because first, the evidence was there, the state had ample proof of the defendant's guilt here. You had eyewitness Bobby Bingham, who had a direct view of the shooting. He identified both the defendant and the victim, and he corroborated the account of the victim's daughter that she provided in her forensic interview. She said she was watching from the door window, and Bobby testified he saw one of the children at the door window. So you have those eyewitnesses, and then you've also got the two neighbors who Mr. Stevenson heard and saw the defendant and the victim arguing the morning of the shooting. He also saw the defendant with a gun, and then you had Tommy Jackson, who heard the victim and the defendant arguing shortly before the shooting. And then you had the defendant's own claims that he was trying to move the victim, that he tried to give her CPR, and then testimony that he didn't have any blood on him. And taking all of this evidence together, it overwhelmingly establishes the defendant's guilt. And the challenges that have been made to this evidence are largely just issues of credibility. And the jury was made aware of all of the things the defendant claims makes the testimony of these witnesses not credible. The jury had the opportunity to make its own credibility determinations, and nothing in the record suggests that this jury instruction impacted or affected the jury's verdict, particularly since the state went the opposite direction of criminal responsibility. It specifically and consistently argued that the defendant was guilty because he was the person that shot the victim. And since there was no risk of the jury sort of being steered towards this theory, there's just nothing here to show that consideration of the issues necessary to do substantial justice or that there was a violation of a defendant's substantial right. And then similarly, the defendant is not entitled to plain error relief on the issue of the pro se pleading. Judge Dyer, I think you suggested this in one of your questions, but the idea that this basically was self-authenticating because it was signed multiple times, it was notarized, but even if it wasn't self-authenticating, there were still enough unique characteristics about the document, including the representation to the court that it was something the defendant had filed, that established this was indeed a pleading that the defendant authored. And it also played a relatively small role in the state's case. It was used to impeach his prior statement to police when he described the night of the shooting, but they were relatively minor grounds for impeachment, and that doesn't negate or nullify the multiple eyewitnesses who saw and heard the events around the shooting and who identified the defendant as the shooter. So it was not plain error for the trial court to admit this pleading. Regarding cumulative error, this court has never held before, nor has our Supreme Court held before, that this is an issue that can be raised for the first time on appeal, and it's not a conclusion that this court need reach here, because that would be inconsistent with our case law and with the Tennessee Rules of Appellate Procedure. The whole purpose of raising issues in the trial court is to allow parties to develop their positions on these issues and to allow the trial court, the first crack at ruling on the issue and potentially obviating the need for an appeal. But allowing a claim of cumulative error, particularly when it involves claims not even raised in the trial court, removes the trial court's role as the first arbiter, the first court to rule on an issue. And so this court should continue to follow its prior precedent and determine that cumulative error must be raised in the new trial. And then turning finally to the sentencing issue, the state concedes here the sentence, it's illegal, it's illegally lenient. But the remedy here is not a remand to renegotiate this agreement. What this court should do.
Is there an agreement? That's the defense argues it that way in its brief, and at least my reading of your brief tends to suggest that you agree that there's an agreement, but this is a jury verdict, and the parties can come into the sentencing hearing and say, Your Honor, we've agreed on this, but it doesn't matter, does it?
I think you're right, actually. I think that the state did sort of present this more as an agreement, but you're absolutely right that it's an agreement that's not binding on the trial court.
It's really a recommendation.
Yeah.
Exactly, it is. It's a recommendation, and here the court happened to accept it, but it's not a binding agreement.
I mean, the example that I've been trying to rack my brain for an example as we're talking about this, but the parties can come in after a conviction and say, Your Honor, we recommend probation. And the trial judge can say, no, well, he hasn't violated any sort of agreement, and if we then review it and were to send it back, it's still back up to him or her as to whether or not they want to grant probation or community corrections or whatever.
Right, no, I think that's a good example, and I do think that's what we have here is just there was a recommendation made to the trial court, but the court happened to accept it. It's not a binding thing like a plea agreement here, and that's where the remedy, again, is to impose or remand for a corrected judgment that reflects the appropriate release eligibility percentage.
Well, is this one of those situations where if the record is sufficient, we can fashion a sentence?
I believe that this court could do that. I'm not entirely sure that the record is sufficient enough, though, just because the state really didn't have the opportunity to make a full-throated argument for the sentence that it would want. But I think it certainly is within this court's authority to set a sentence. But what would potentially make the most sense that hews the closest to the trial court's findings or the trial court's imposition of a sentence and the statements between the prosecutor and defense counsel would be to leave that 4-year sentence intact, but impose the 85%.
Well, that was going to be my question. I mean, really, it's just changing a percentage.
Right.
I mean, if we remand it back, nothing precludes the trial judge from deciding to go to the maximum or deciding to go to the minimum. He's got to impose the right percentage. But to Judge Easter's question, there's enough in the record where we could just leave the numbers where they are other than change the percentage.
Yes,
which is the required percentage by law.
Yes, this court absolutely could do that. So I believe that's certainly a way forward. here. And just changing the percentage, again, that seems like a logical remedy that is consistent with what the record bears out, that this is what the parties wanted the sentence to be, that the 35% release eligibility really didn't factor into this decision to make an agreement. What was the overriding factor here was the desire to shorten the potential sentence. And so, yes, the state would submit that this court could either impose the sentence itself or remand for entry of a corrected judgment reflecting a legal release eligibility percentage.
And this is one of those sentences that is mandatory consecutive as well.
I believe so.
So we wouldn't, it was a recommendation agreement, whatever you want, it was consecutive. 4 years, 35%
Yes, Your Honor.
consecutive. So I'm thinking, I believe that this is a sentence, it's mandatory by statute to be consecutive and also at 85%.
Yes, Your Honor, that's correct. So there's not sort of a separate exercise here of the trial court exercising its discretion to impose consecutive sentences. You're absolutely right. It was required by law. And so unless there are any further questions on this or the other issues, the state would rely on its brief for the sufficiency argument and ask this court to affirm the defendant's convictions and enter a sentence that reflects the correct release eligibility. Thank you.
Questions? Mr. Chisholm? In rebuttal.
Thank you, Your Honor. I would like to just pick up where we left off there about the mandatory consecutive. I don't think this is mandatory consecutive because we have a second-degree murder and a felon in possession of a firearm all happen on the same date. And so it's not like employing a firearm has to be consecutive to the dangerous felony. Here we just have felon in possession of a firearm with second-degree murder. So I think the reason they made it consecutive, they were trying to get the number up to 25 years, and they're working a way to. But anyway, again, I would just ask the court to send it back and to let the parties have a chance to renegotiate would be my position. The only other thing I'd like to just briefly reiterate, the state mentioned that as to the faulty instruction that, there was really no argument steering the jury toward criminal responsibility. But again, I respond to that by saying there was evidence that steered the jury toward that theory because they heard about the gun being found with another person, and that in and of itself could have led the jury to believe somehow Mr. Williams is involved with this guy who had the murder weapon, the carjacking suspect, and that evidence in this case is what really creates that potential problem in this case. And that's why I think that instruction was really prejudicial to Mr. Williams under these particular facts. May not be a problem in 9 out of 10 cases, but in this case, that's the problem. And I'd respectfully ask the court to reverse the conviction based on that constitutional error of a faulty jury instruction, plain error. Thank you.
Thank you. We will take the matter under advisement. Madam Clerk, call the last case, please.
Aaron Malone versus State of Tennessee.